All right, good morning. We are live. This is Attorney Vincent Davis, and this is The Secret: How to Fight CPS and Win. I'm joined this morning by my co hosts, Miss G, Miss Georgette Truan. Miss G, how are you this morning?
I'm good, thank you.
Good. We have a guest that's logging in. Hopefully, she had some issue with her children. She was working with one of her children. So if she comes on, great. If not, maybe we can answer some questions from the audience, and maybe we can answer some questions that you may have for me, Miss G.
Um, I do have a couple of questions.
Okay.
This came from a viewer from last night's show. Asked if is it possible that you would work with my court-appointed attorney? If so, do you require a small retainer to do so?
The answer is yes and yes. However, I must say that the attorneys that agree to work with me or have me work with them, is a very low percentage. But as long as the attorney is okay with it, I'm okay with it.
Okay.
I'm actually doing that right now in a trial in Oklahoma.
Oh,
I'm doing exactly what you just asked, except for the attorney is not a court appointed attorney. He is a private attorney.
okay.
And from my interaction with him so far, he's appreciative of the fact that I'm in there, with him trying to, help him win this case. It always
Okay.
helps, I think. It always helps, I think, when you have another set of eyes, looking at the case. Because this guy is actually, I mean, he's a very competent attorney.
I think a wise attorney would want to work with you to have you on his team. That's my opinion, truly. Um, Another question: would Mr. Davis be willing to talk about the de facto motion? Please, I need help.
Sure. A de facto motion is a motion that is filed by a non parent to give a person as standing inside the court. So it's actually called a de facto parent motion, and it brings you in to give you almost the rights of a parent in a case and allows you to present evidence and, you know, present your side of the story. There's one thing, though, that I think a lot of people are missing out on. California, a few years ago, passed a law called the Presumed Parent
Hmm.
Statute, which gives you even more rights than the de facto parent. And I think that in a lot of cases, that should be considered. Everyone may not qualify as a presumed parent, but they
Hmm.
might qualify as a de facto parent. But you should take a look at it because it gives you more rights. Because obviously, you are a parent.
So it gives you more rights. I mean, can you explain that to me?
Sure. When you're the mother in a case, you have
Right.
certain rights,
Right.
constitutional rights, statutory rights.
Hmm.
Okay. Let's say that gives you, on the scale of legal rights, it gives you a 10. Well, a de facto parent motion, depending on the circumstances, may only give you a 5, a 6, maybe a 7.
Hmm.
Okay. So it's relative and it's fact specific. In other words, I can't tell you what rights you would have as a de facto motion, as a de facto parent in this case without knowing the facts and circumstances and the procedural posture of the case, meaning where is the case on the Davis sliding scale of modules? Is it module one? Is it module two, three, four, five, six? Okay.
Okay.
So it varies. Presumed parent means you're the parent, just like the bio mom, just like the bio dad, like the presumed father. I'm involved in a case now where there's a bio dad, and he may not get reunification services, a chance to reunify with the child, because he hasn't and may not be declared the presumed parent.
Oh, really?
Yeah. So California is kind of unique in that it has 5 or 6 different types of fathers, right? You think, oh, I'm the bio dad, I got all the rights. Not true at all. You have to be declared the presumed dad in order to get rights and to get reunification services.
And can that be done during the, I guess, the stages of the case, or
Well,
I mean,
yeah,
how can that
definitely,
be?
definitely. So
But
I'll give you an example. In the case that I'm involved with right now,
yeah,
the I represent the mother, and her story is that she got pregnant and the dad disappeared, never to be seen again. And he never supported the child. He never held the child out as his child. 7 or 8 years later, the mom gets catches a CPS case, and the CPS worker, does what she's supposed to do. She locates the bio dad. In this particular case, the CPS worker wants the father, the bio dad, even though he's never seen the kid. He's never seen the kid, before this case started. Wants the guy to be a presumed father, get reunification services, and
right.
possibly get the child. Well, my client is her position is she's against that. Her thing is, look, he's never been around, literally never been around, never
Right.
seen the kid before the case started, never supported the kid, even though there was a family law action that
Unbelievable.
declared him to be the bio father and declared him to pay child support. Allegedly, he never paid child support. Never seen the kid, never paid child support, didn't hold the child out as his own child, and 8 years later comes forward and says, "Oh yeah, I want the kid." So you tell me, is that fair to the kid? Is it fair to the mother? Is it fair to the father? Is it fair to our society? I don't know. I don't make those kinds of decisions. But that's where you could be a bio dad, and if you're not the presumed dad, you're not going to get rights in the juvenile dependency or CPS case. Does that
Okay.
make sense?
It makes sense now, but before the guest, I know she's on there, but she's waiting to be end the show. But I have one more question. I'm sorry. Um, Again, this person asked, "What is the Is the 388 petition the same as the 827 petition?" I've
No.
never heard of 827, to be honest, but
Right. So the 388 is to file something post disposition hearing to change or modify a current court order
mm-hmm,
or to get additional things that you may want out of the case.
mm-hmm,
And by the way, a 388 can be filed by anyone. Man walking down the street can file one. Doesn't mean he'll win, but he can file it. The statute actually says, I believe, any person can file a 388 to request something, some type of relief from the judge. Okay, usually to change or modify a court order. An 827 petition is a special petition where a person files to get a copy of the court file and or the social worker's file. Okay, so that's filed by a person who's not a party to the case. Although I've seen county council in some cases argue that even if you're the parent, you have to file an 827, which I don't agree with. But in order to get a copy of the file and the social worker's file, the court file, you got to file an 827. And then 827 says to the judge, "Hey, judge, I have a really good reason to have a copy of the file. And here are my reasons." And then the judge looks at it, will set a hearing, may approve it, may, set a hearing where people come forward and argue one way or the other of whether there should be a disclosure of the records or a modification of that. Where we use it a lot is somebody comes to us and says, "Hey, I want to sue the social worker, and I don't have a copy of my file." or I don't have the entire file. As their attorney, we file what's called an 827 petition to get a copy of the underlying CPS case so that, we can evaluate and so that we can prosecute the civil rights case. Interestingly enough, when law firms represent the social worker in the county in civil rights cases and they defend them, they too have to file an 827 petition to get the reports, get the documents from the court file, because if they don't, they can't use them at the time in the trial or in the hearing or in the lawsuit. So they too have to file an 827. It's basically giving notice to the court and to the world that you want a copy of these confidential records. Because don't forget, and a lot of people, take this for granted.
Mm-hmm.
You cannot look at a CPS court file unless you're one of several people listed.
Mm,
So if I'm an attorney and you work with me as in my office, we
mm-hmm.
can't look at that file unless we file an 827 and it gets approved,
Mm-hmm.
even if the client was the parent in the case. So it's all very, very confidential and it's strictly enforced. Um, I will tell you that this is how strictly it's enforced. We had an attorney that used to work for us who gave a copy of the file to our expert. I think it was a therapist. Now, in my mind, that is okay. But
Mm-hmm.
in the judge's mind, and it was a judge up north, he reported her to the state bar for violating confidentiality in a CPS case.
What?
Yeah. Now, luckily, as I recall, the state bar didn't take any action against the attorney because I think it's okay because the expert is your expert, part of your legal team, and you get to see the records. Yeah. But the bottom line is that some judge thought it was a violation of confidentiality.
And I
Many,
think that's
m-
because,
m- many years ago, I was involved in a case up north where I did the same thing, and the judge called me out on it, and I stood my ground. I said, "Look, that expert is part of my office, covered by my ability to see the court records, and I represent, I think I represented the mother in that case." The judge never did anything because I think she thought, well, Davis is making a good point, right? But,
now,
there's a lot of procedural problems with 827. It takes a long time to have a hearing get granted. If you had to wait for that, you'd never be able to defend your client with an expert in a CPS case.
and how much would the expert, like, that's a different kind of charge, right? There's a different kind of, when you hire an expert, you have to pay them, obviously, correct?
Yeah. Yes.
And you do have an expert. I mean, you have experts
We
that
have
work with you.
Yeah, I
I guess
have,
that's my point. Yeah.
been doing it a long time, know a lot of experts, medical, psychological, that type of thing, civil rights wise, people that we can consult with,
Right.
because expert witnesses are important to a lot of cases,
Correct.
because they get on the stand and actually testify. I can't get on the stand as the attorney and testify. That's why they have expert witnesses.
Okay. One last question, and I know, but she keeps texting me. Um. Oh.
Is this from the same person?
Yeah. But
I'm thinking about limiting questions to one question per show, per person.
okay, it's a different person. Um. I lied, but
I'm going to be only taking questions from the postings.
she is on there. She's
I don't see it.
she's on there. She's watching. Um. The petition for, she said, the petition for legal guardianship, both temporary and permanent. Um. What does that mean? That's all I have.
Okay. I think she might have gotten that from one of my videos because I'm the only person that I know that talks about legal guardianship, temporary and permanent. Um, there are two types of legal guardianship: a a temporary legal guardianship
Uh-huh.
that's given pending the outcome of the permanent legal guardianship hearing.
Okay.
Okay, so sometimes you can get temporary guardianship but not get permanent guardianship, or vice versa. Or you can get them both, temporary and permanent, or you can lose them both, temporary and permanent. Different powers, different standing with the court, and of course, temporary means just what it says. It's only temporary, it only lasts a few weeks or months. Okay?
Okay. And Anna Lizer Fields, he or she has a couple of questions also. Can you please address it whenever you can?
Yeah, we'll try to come back to it.
Okay.
All right, we have Kylie. There you go. You adjusted that picture really good. How are you?
Good. How are you?
Good. So, Kylie, where are you coming from?
I'm from Ventura County, California.
Ventura. Okay. One of my least favorite places to do a CPS case.
I have a feeling I understand why.
You know,
um,
I'm going to tell you something that happened to me in Ventura. This is years ago. I was on a case, and there was another attorney on the case who was representing, I think he had the father and I had the mother. But one of the things that he was trying to argue is that the social worker had some type of, or the county had some type of financial interest in the case. And the judge in that case said she didn't believe that. They have no financial interest in the case, which is, in my humble opinion, not even close to being true.
I was going to say
But anyway,
BS, politically
you
correct
know,
version.
but anyway, so what's going on with you in Ventura?
Well, I was never a child involved in the system, so I don't have any history with that. I have a daughter who is 12, and I had her for the first 6 years, and then I was in an abusive relationship that went upside down. I sent her to Texas to be with my mom voluntarily. Like, I placed her there so I could get
Mhm.
back on my feet. DCFS came poking around just because she kind of like disappeared from school very suddenly. But I just, told them the truth that I had assigned temporary guardianship with my mom because I was trying to get a job and get my own place again.
Which you
So
can do, by the way.
yeah, right.
Which you can
So that
do.
was like the extent of my contact with them. Fast forward, this is like I said when she was 6, to I was pregnant and I had just gotten out of prison, gotten a relationship really fast, got pregnant, which our relationship was extremely toxic. I ended up relapsing when I got out of prison. But I got sober before I delivered my son. So in the hospital, my cord tested dirty, but we tested clean at the hospital. So they came asking questions, and I was just honest with them. But at that point, my son's father was heavily still active in his addiction, which was evident to everybody. The nurses at the hospital, I mean, it was embarrassing delivering my second baby and having him, not be present. But so they came asking questions. We were honest with them. They assigned us family maintenance, or I'm sorry, family preservation. And we were assigned some services. I quickly started doing them. One of my goals in that was to remove him from my home, which I did. It was ugly. The police got involved, but my FP case closed. He was bypassed. He didn't do anything. Fast forward, my son was born in December 2020. My FP case closed. It was like exactly at 6 months from that. So I want to say June, July. Then I didn't have any other issues. Then in June of 2022, I was hanging out with somebody that I worked with at a treatment place, and she was still using. And I made the really stupid decision to get a ride from her. I ended up going to jail, being investigated by parole because we were in the same vehicle. That night that I was arrested, my son was with the paternal grandmother. So at this point, his dad is still using just sort of MIA. I would supervise visits, but only when I know that it was me and not his mom. Side note, in my FP case, when we did our safety plan, they closed my case knowing that I may have to do 60 days from a very old case. And I assigned my mother as my safety person to take my son if that came to fruition from a 2017 case. So DCFS made very clear that my son's father's mother would never get placement due to her inability to like set boundaries with Frankie. She enables his using. And basically it comes down to they didn't believe she would choose my son's safety over protecting her own son and his like lies, if that makes sense. So I'm arrested 5 days after parole does their investigation. They released me. I was still sober. The day I got arrested, my son was with paternal grandmother because I was supposed to be working overnight. And I don't have family in California anymore. So I utilized her sparingly. I was arrested. She went with father and immediately filed for emergency custody, which then triggered the courts to go, well, wait a second, where's mom? And they claimed I abandoned him. So they forcibly came in and removed my son, who was 18 months at that point. After 5 days of being in jail, coming out to my whole world turned upside down. Like I said, parole didn't violate me. I was released. I never violated my parole, and I tested clean. They said I had no plan for him, and basically were agreeing that I abandoned him. So they placed him with foster care. At that point, when I got out of jail, and after the first day of being home, I relapsed and I overdosed. And I was found unconscious. I quickly put myself into a treatment place. I didn't let that become like the path I wanted to go down. And I stayed clean. So that was June of last year. And this whole time I've been doing family reunification. Eventually my son was placed with paternal grandmother. And she works at a treatment place and was forging certificates and you name it for dad, just making him look like he was doing everything. To sort of keep it short, he left sober living in March, and the first day he left after almost a year of being sober, he relapsed. The first day he was out on his own, and he died in March. So the mom knew, though she's telling everybody she didn't. My son was due to move in with his dad very shortly after this, so I just thank God every day that he wasn't in the house when that happened. My case is set to close in August. I've complied with my services. I've tested. But this whole thing has traumatized me. Like, their whole basis for taking him doesn't make sense because even with the services that they reassigned me in reunification, I voluntarily continued to do those services for almost a year after my family pres case closed. Like on
Wait,
my own.
hold on a second. Do you have the child in your custody?
I've worked up to, I have all weekends, but
Okay.
yeah.
Okay, so I'm going to stop you for a second. And I want you to listen to this very carefully. All right? What you are doing is trying to use common sense and understanding a system that is not based upon common sense. So if you keep trying to figure it out, you're going to drive yourself crazy because you're never going to figure it out. Okay? So I know that you're old enough to realize this. There are many unfair things in life. This is one of them. This whole CPS system. So don't get caught up into that morass. The fact is that they got involved with you, and it's your job, and the only job you have right now is getting the child back. If you want to take action to sue them, you must have your child back in your custody. Okay? Until you get that, don't even think about remedying the situation, because you will go off into left field, and you will start doing things that aren't important or aren't going to support you getting the child back. And if the social worker ever found out you ever thought about suing them, they will retaliate, in my humble opinion, and you will not get your child back. So here's something though that you should know. And Georgette and Darren's not with us, but we talked about this a couple weeks ago. You know that is there something wrong, Miss G?
Yeah, I got like 15 questions for you, but I can't do it.
Okay. Let me mute you because we don't want you to. Okay. Kylie, this
Yeah.
is really important. You should talk to your attorney because in juvenile dependency law, CPS law, if you're having unmonitored visits with your child, you're supposed to have the child placed back with you. There is case law in this state that says there's no such thing as a step-up plan for CPS cases. It's either you're a risk and you don't get the child back, or you're not a risk and you get the child back. Many, many, many judges, even above my objection, use that step up plan. Oh, we're going to give her one overnight. Oh, we're going to give her two overnights, and we're going to work up to that. To be honest, and I was talking to someone about this, a few months ago. That particular theory is probably a violation of your civil rights, but that's what they're doing. And I'm not telling you to buck that system now, but keep doing what you're doing, because if you ever have to have a hearing, if you ever have to have a trial, the fact that you're having unmonitored visits will go a long way if you lose, because on appeal, the Court of Appeals may say, well, wait a minute. You gave her the kid for overnight weekends and you won't give the kid back to her? That makes no sense under our current laws. Do you follow what I'm saying, Kylie?
Yeah.
Okay. So when is your next court date?
It's August 3rd.
And what type of hearing is that?
They're recommending dismissal.
Giving you the child back and dismissing the case?
Yeah, because I told my attorney that I do not want to do family maintenance, that I want to go back to Texas where I have family and support, where my daughter is currently most of the time with her dad, who's around more. So yeah, I want to leave California as soon and quickly as possible. So
Might be a good idea, or at least that county.
yeah,
But
definitely.
going back to family, for support is always a good idea, in my opinion.
Yeah.
Does the social worker know that?
Yeah. I just have had to be very careful about his mom finding out, because up until he died, she was just very vindictive, and it was like a contest,
The father passed away?
Yeah, he died in March. When he got out of sober living, the first day he was out, he relapsed and died.
Hey, Kylie, can you believe this? Miss G is calling me on my mobile phone. Did you know that, Miss G?
No.
You're calling me right now on my mobile phone.
Oh,
you
wow.
you hung up.
I don't even I'm not even holding my phone. I'm holding this.
That's crazy.
I'm just telling you.
Okay then.
Anyway, Kylie, you are doing everything that you're supposed to be doing. Okay. And it sounds like you're getting on the good side of the social worker. I'm not going to tell you things to screw that up.
Yeah.
Okay. Because if you get too aggressive, then they'll retaliate against you. You're getting your weekend visits. You know, what I might suggest, you talk to your attorney about this, is turning your weekend visits into a 3-day weekend visit.
I have 3-day weekends now.
Okay. And if it's a
Yeah.
3-day weekend visit, turn it into a 4-day weekend visit.
Yeah, they basically said that they want to be able to show the judge by the time we go to court that I've had him for like an extended period of time to favor that dismissal. So I mean, at this point, I think every week, pretty much, as of last week, she said they were going to add a day and then just make it like pretty much by the time we go to court, I think she said the last 3 weeks or 2.5 weeks would be with me completely.
Okay.
But I said
Well,
I'd prefer, like a month at the rate we're going up. I don't see why that shouldn't happen.
right. Right. Well, I mean, it sounds like you're well on your way. You know, keep doing what you're doing.
Yeah.
And then if you have some issues regarding the unfairness of the way you were treated in the case, you can always talk to a civil rights lawyer after you get the child back, and preferably after the case is closed.
Yeah. Hi. You can come here.
No, she can't be on the video. Yeah.
No, I'm turning it up. Yeah. He hurt his finger, so he
Oh,
went to snuggle. But I appreciate that, and yeah, it's not necessarily me. It's more him because he's suffered unnecessarily. He has chronic ear infections and was due for tubes a week after he was removed. And because, she was entitled to take him to a whole new doctor and get referrals, it's been a year and he still has not received those tubes.
Hmm.
And he's delayed speech. And, it's very hard to see him in pain when it could have all been avoided.
yeah.
So
Well,
that's
after you
really
get
what it's about.
do this, after you get the child back, the case closed, call Miss G,
Okay.
and we'll see what we can do with helping you with some type of remedial action. Since he's
Okay.
right there with you, I'm going to end our interview.
Yeah.
I want to
Yeah.
thank you for calling in, and I
Thank you
appreciate
so
it.
much. I
And have a
appreciate
good
it.
weekend. Bye-bye.
You too. Bye, guys.
Bye.
Miss G, there's only one thing worse than mentioning somebody's name on the show, and that's having the child's face on the show.
I know. I was so scared. I was like, oh shit. Oh, but at least she's smart enough to not put the child. She moved her camera up, so she was smart enough to figure it out.
Okay.
But I got like 15 questions. I told them to put it on the show, and 2 of them said they did, but they don't see it. I don't know what's going on.
Okay, how many minutes do we have left? We have a few minutes left on the show. Why don't you start asking me questions, and I'll start giving you answers.
Well, first of all, I do want to address Analyzer Fields, because they did have he or she had a couple of questions. Do you see it, Vincent?
I see it. She has a bunch. Yeah. Can the CPS workers declare who they want the father to be versus bio father versus legal father by marriage? Analyzer, the answer to that question is they can support whoever they want to support. That doesn't mean that that's going to be the judge's decision.
Mm-hmm.
What you and your lawyer are going to have to come up with some law and evidence to get the person declared the presumed father that you want. Now, here's another little twist on California law. There can be more than one father.
What?
Yeah.
What do you mean there can be more than one father?
What does that mean, Miss G? What did I just say?
Can there be more than one mother?
Yes. Parentage law in California is not common sense. I was on a case one time when they just passed these laws that had 5 parents. One kid, 5 parents. That case was down in San Diego County. One case, 5 parents. 1 kid, 5 parents. So the law in California is that you can have more than 1 parent. And that recognizes the fact that bio parents aren't the only parents a child can have. Now, you can debate that any way you want it. I'm just telling you what the law is. You stop on red, go on green. That's just the law.
They can't even acknowledge the real parent. How can I guess to me that's just they just make up rules like Kinsley said. They just make up rules because
Well, yeah.
if
I
they
mean,
can, if they have a hard time acknowledging the actual biological parent,
right. And so what?
but yet they have the audacity to acknowledge the non-parent as a parent.
Absolutely. That is the law in our state, Miss G. Now, there's 2 things you can do with it. You can either get with it and use it to your client's advantage, or you can go out and try to change that law as being, you know, not in the best interests of our society. Either way, you know, I only help people get what they want. That's what a lawyer does. I try to refrain from political commentary about laws because, interestingly enough, a lot of laws are made for situations that you would never dream of. And if you knew the real situation, you would say, "Oh yeah, I get that. That's fair." The problem is that someone comes along, usually a smart attorney, and turns that law on its head and uses it for some completely different reason.
That's what you do. I've seen that. That's what you do. I called you the legend yesterday on my show.
Oh
I
wow,
said I work for the man, the legend, the one only, Vincent Davis,
is that is
because
that is that legend with a capital L?
yes, and I actually the reason I mean
You know,
again
you know, you
your
know,
strategy is so weird, but
you know what it is that people think that whatever they want in the law is always right ethically and morally, right?
I used to
And
think like that. Remember,
yeah, and it's not true, unfortunately, or fortunately, I don't know.
I used to
Mhm.
think there's common sense in the court, right?
Well, no, yeah, come on. There's the law. There's the law. You know, I recommend this to people. A lot of people have asked me, "Hey, man, what's your most important YouTube video?" The most important YouTube video that I've ever done is the one called "What is Justice?" where I'm
Mm-hmm,
standing in front of a whiteboard. There's another video called "What is Justice?" I think too.
mm-hmm.
But the one where I'm standing in a whiteboard, it's about 7 minutes and a few seconds. I think everybody should watch that video and understand what I'm saying.
Mm-hmm.
I don't care if you agree with it or disagree, right? Look at it and understand what I'm saying.
Mm-hmm.
Because I've only been doing this as of December this year, 37 years. Okay.
I have
Take,
seen it. Seen it. Um, Now the other question is, if the legal father, if the legal father lost his son, will the mother I magically? Okay, I don't understand this.
yeah.
Will the mother?
First of all, legal father is not a term used in California. So I don't know what she means by that.
I know that's legal. I guess this Anna meant the biological father. If the biological father lost his son, that's what I think they meant. Will the mother magically lose the rights to their children from another father? Okay, so hey, okay, I
The,
get
the,
it now.
the answer is, Analyzer Fields, maybe. You know, that's kind of a loaded question. It depends on facts and circumstances. You know, a lot of people ask me questions, and I'd say 95% of those questions, they're not black and white answers. You know, they're based upon facts and circumstances. The law doesn't exist just in a vacuum. Unfortunately, everybody wants, that magic pill. Is it yes or is it no? Well, it's not like that. And I'm sorry to say that. And
I think,
how many years as a lawyer did it take me to accept that? Probably 10. Even as a lawyer, it's hard to accept. It's that personal struggle you go through because you think in your head you know what the law is, or you think you know what the law should be. And it's not like that at all. Not like that at all.
but I don't know if that answers her question, because she goes on to saying, if the father she declares is the bio father turns out to have a negative paternity result,
Then he's not the bio father.
but she declares it, I guess, him to be the biological father, maybe
She
because,
can't do that. She can't declare the biological the father. She can declare other types of fathers, right? And there's a motion that he can make for certain parental standing as some type of father. Remember, I told you in California there was like I,
Mhm.
5, maybe 6 different types of fathers in California law. In dependency, they usually deal with presumed fathers and biological fathers, because that's the only real issue if you're presumed, if you're going to get family reunification services. Comes
Wow.
up a lot though in family law cases, and especially in adoption cases and
Mhm.
adoption litigation. So I hope we answered Analyzer Field's questions. Susan Green Adkins, what can we do if juvenile lawyer and social workers are doing the quote work up to quote unsupervised visits? We are 11 months in and still have supervised visits. Kids are teenagers.
Oh my God. The kids are teenagers? Okay, that doesn't make any sense, Vincent. Does it?
Well,
They're teenagers,
I just,
Vincent. They're probably
I
3 years from being legal
I
age.
just, I just told you everything depends on facts and circumstances. What if they're 13 and not 17? What if they're 15 and don't want to see the mother or the father? What if 101 different things? But generally speaking, she's asking a question which I kind of hinted to 2 questions or 3 questions before. There's no workup visitation in CPS cases. There's not, that doesn't exist in the statutory scheme. There's a line of cases. Either you get the kid back or you don't get the kid back, not workup. Workup visitation is in family law, family code, California family code in California. In CPS cases, either you are a risk to the child or a danger and you don't get the kid back, and there's none of this workup. I acknowledge, I'd say even maybe 90% of judges still do the workup visits in CPS cases. And
Uh-uh.
when I've objected to it, um, it hasn't gone very well. It's almost as if, well, I dare you, Mr. Davis, to take a writ on that. Spend $10,000 and 3 weeks of your life, and by that time the kids will be placed with your parent permanently, or they won't be placed because she tested dirty again.
Okay, well, she already gave us the ages. Now she says judges has repeatedly deferred to social workers' judgments. Exactly. See, this is these. I'm sure you see what she wrote, Susan. This is exactly what the judges do. They always defer to the social workers' judgment.
Well,
What
first of
does
all,
that mean?
let me tell you something. In a lot of cases, in a lot of circumstances,
That's ridiculous.
the judge has the right under the law to do that.
This is
You-
ridiculous, though. This is so
Well,
disgusting, though.
you
Come
know, I
on,
just, I
Vincent.
just,
Come
I
on.
I just told that lady, if you're looking for common sense, you're always going to be disappointed.
It's not even about common sense at this point.
It
A
is.
social worker. No, I can have a judge. I can have an opinion of you. That doesn't necessarily mean it's true. Correct? That's just my opinion.
Mhm.
So my opinion without facts, it means crap, right? So the judges, when it comes to the livelihood of a family, they shouldn't just go by what the social
Wait,
worker is
stop
saying.
it. You just said the wrong word. You just said the wrong word. Shouldn't. That's your personal opinion, which means 0 in these cases. People are going by the law. Okay? And I just told you, the judge has the discretion to do that. Now, if the judge abuses that discretion, you can file a writ or an appeal. Or you can set the case for trial, which a lot of people don't do for some reason. All right? So
Okay.
there's a rule book. Let's play by the rules.
Okay.
Don't
Can I
tell me
just?
about this common sense BS.
It's not even about common sense anymore. It's just
Look,
um.
Lloyd says, Attorney Davis, if you lose the jurisdictional hearing but win the dispo and custody of your children, would losing the jurisdictional hearing have negative impacts in a civil rights lawsuit? Yes, possibly. Again, I need to know the facts and circumstances, but the answer is yes, possibly it would have a negative impact, Lloyd, because there's something called res judicata and collateral estoppel in the law, where if you lose in one court, you cannot try to challenge that in another trial court. What you could do is you could file an appeal after the dispositional hearing, since you won the dispo, and appeal those negative findings against you, from the jurisdictional part of the case. So, Lloyd, you can do that. And then Susan says, is there a specific case law I can quote?
Yeah, I get that a lot.
Yeah, there is. I don't have it memorized offhand, but you could Google it, or you can go on LexisNexis or Westlaw to find that case law. But there is case law on it. I'm not one of those guys that memorizes cases.
So the
Although I did a trial yesterday, and another attorney from our office was watching it online, and he was impressed that in the closing argument, I cited a case. It just came to my mind.
how do you feel about people who lie to you as an attorney handling their case?
Um, Maybe it depends on how the case turns out, but maybe a little disappointed.
But do you usually leave the case if they lie to you?
It
Because I
depends
have
on it depends on what it is. If it's something material that causes a conflict, the law requires me to try to get off the case. But
a conflict. Like, what do you mean a conflict? Explain that. Like somebody, I don't know what
conflict of
you mean by that.
interest. That's
Conflict
a
of
conflict.
interest.
Yeah.
What is a conflict of interest to you people?
Again, it depends on the facts and circumstances. But the way I was using it is, they have. I'll give you an example. They get on the stand and testify ABC, and later tell me ABC is not actually true. And if case is still not going on, um, I might have to withdraw from the case. I did a case recently where the client testified. The judge found that the client was not being honest and lacked credibility, but the client is still telling me that the judge is wrong, and she did tell the truth, and she wants to appeal it. So that's not really a conflict of interest right there, because she still contends that it's true. The judge just made the wrong decision.
Yeah, how many? I mean, in my opinion, I think most judges make the wrong decisions all the time because it's very hard for me to swallow the fact that they make decision based on lies and they believe the experts, as a couple of judges would say, the social workers who barely probably graduated high school.
I
Um,
can't I can't wait for you to become a lawyer so that
Me
you
too. Me too.
so that you can
Me too.
tell me a
I
fact.
know, but see, I know, but it 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 absolutely doesn't make any sense to me, and it will never make sense to me. It will never make sense to me.
About 8 years after law school, you will say, now I understand what Davis was talking about. Hey, we've come to the end of the show. I want to thank you for joining me as co-host. I want to thank our great guest, Kylie, And we will be back tomorrow at 9:30 a.m. Pacific Standard Time. We'll see everybody then. Bye-bye.
Bye bye.